I was born in Puerto Rico. My father's Puerto Rican. My mom is Mexican American from Eagle Pass on the border. Had been always interested in issues involving the Latino Hispanic community. In law school, I started developing interest in this area and how the legal cases and system has at times treated Latinos differently. I think that part of the intellectual academic pursuit of any study is compare and contrast. My third year in law school, I was able to teach an undergraduate course on this topic, and so that gathering the materials for that and borrowing from other people who had taught similar courses and doing investigations led me to teach that course. I taught and assisted in teaching at the University of Texas, and then ultimately when I came to Austin, and then ultimately published the book, which was a condensed version of the course, focusing on the Supreme Court cases as opposed to just general legal issues. Sure, and this will bring a lot of people back, I guess, to law school maybe, or some kind of history class. But there were just a series of widespread changes brought about by legal decisions of the Warren Court, Miranda versus Arizona, a lot of things having to do with the rights of the accused in criminal matters, as well as civil rights issues involving education. Obviously, Brown versus Board of Education is literally the case next to Hernandez versus Texas, decided by the same court, 9-0-1954. Then also in the field of education, of criminal justice, of voting rights, all kinds of things. The court opened the sphere and had certainly a broader interpretation of the Constitution than prior courts, or I'd say subsequent courts. Sure. I think Hernandez versus Texas is a landmark case because it really sort of plants the flag in the middle of the civil rights movement, largely involving the rights of African Americans and many others. But as a case that says that Mexican Americans in particular, and in particular in Texas, are an identifiable protected class, which under the constitutional law structure meant that a protected class or a suspect class was entitled to strict scrutiny. And so laws either on the books or by practice that discriminated on the base of race or being a suspect class would be looked at more carefully and subject to strict scrutiny. So that's one of the reasons from a sort of legal perspective. Culturally, I think it was just one more way where there was a greater appreciation across the country of the significant populations and the many challenges and problems facing Americans of Mexican descent in particular in Texas and the United States, but also other Latinos. So I think for all those reasons and probably many more. I'm going to answer the second part first. I think it was a little not surprising that it was unanimous because of what the Warren Court was doing in this area. The fact that, like Brown versus Board of Education, in providing that separate is not equal, the real attempt to have the Constitution, fulfill the promises of the 14th Amendment, all that makes it not surprising in a lot of ways that a court with judges appointed by both Democrats and Republicans with different legal and constitutional philosophies all agreed that this was a violation of equal protection. In terms of what the Texas High Court had ruled, and I reread the opinion getting ready for today to visit with you, it was interesting again to see that they did refer to basically what they call a two-class theory of equal protection. They basically, and the U.S. Supreme Court opinion talks about this, that there was basically African Americans and then everybody else, and everybody else was white, this sort of two-class theory. And this interpretation of the 14th Amendment suggested that the only categories or reasons applicable to a 14th Amendment analysis would be African American people who were certainly, after the abolition of slavery and the post-war issues, the main impetus for why the 14th Amendment was passed. But clearly, the 14th Amendment is broader than that. The language is broader, the intent is broader, and the Hernandez case is consistent with that. And they did reject Texas's two-class theory. That basically there's African Americans and everybody else. And in the opinion, they say Mexicans are just white people of Mexican descent or Spanish descent. And certainly that wasn't the way that Mexican Americans were treated in other instances. And I would point out the case of Independent School District of Del Rio versus Salvatierra in 1930, San Antonio Court of Appeals opinion, where there was formal educational segregation of facilities at first through third grade by policy and by fiat of the district of the Mexican schools that were very common throughout parts of Texas and Southwest for a long time, and Anglo schools. So this, and then the U.S. Supreme Court points out that even Texas had, on previous occasions, found that the Equal Protection Clause would protect religious discrimination, such as in that case involved a Roman Catholic person, and exclusion from the jury. So the U.S. Supreme Court rejected Texas's notion that there's only two categories of people for equal protection purposes. Right, and probably 24 years, I mean, from the 1930s, but I mentioned Salvatierra, that's a leading one. There's also other school desegregation cases, both in California and in Texas, where challenges were being levied. There were also public facility challenges. There were also instances where, for instance, what Mario Garcia calls, from El Paso, the Mexican American generation, people after World War II, many had served and came back and were treated as second-class citizens. And there was a stronger commitment to ensuring the full protection of rights for citizens who happen to be Americans, but of Mexican or other Hispanic origin. And so why did it take so long? Because usually these kinds of things do progress. The law develops slowly. It takes multiple challenges, and really it wasn't until the U.S. Supreme Court stepped in and said this is the law of the land that these challenges became an important part of our legal structure, and led to, for instance, in 1964 the Civil Rights Act, and in 1965 the Voting Rights Act, in recognizing Hispanics, Latinos, people of Spanish-speaking origin as being having a right to protection under the Constitution and the laws of the United States. So I'm going to address that in kind of two ways. One is a little bit of the jurisprudence leading up to it, and that's going to tie into something I want to talk about too, Hernandez versus New York, a different but very landmark and significant case for Latinos as well. And then the factual record that was developed in the case. So from the jurisprudence standpoint, there was a case from the 19th century, Strotter versus West Virginia, that said that laws on the books, in that case, West Virginia had a law that excluded Black people from serving on juries. And the U.S. Supreme Court back then found that was a violation of equal protection with regards to jury service. It's not surprising that a lot of challenges happen in the area of jury service, because other than voting rights, jury service is another aspect that's part of citizenship that's super important, mentioned multiple times in the Constitution. Then later on, there was a case called Norris versus Alabama, where the same situation with regards to these grand juries and the complete exclusion of African Americans, but not by a law that was written on the books, but by a practice that resulted in what's called the rule of exclusion. And so that's what Hernandez versus Texas addressed, was, does this rule of exclusion by systematically excluding Mexican Americans from participating in the grand jury process deprive Mr. Hernandez of a fair trial, because he was not, didn't have a jury of his peers. And so that was, and by the way, the case was also very clean in that there's no question he killed Espinoza. There's no question as to any other aspect of the case. It was solely, does the fact that there was systematic exclusion of Mexican Americans from grand jury service and petite jury service in Jackson County mean that he was deprived his equal protection rights? In terms of the facts of the case and what was developed, and it's many of it, a lot of it's in the opinion mostly, but there were signs in the community saying whites only. We are familiar that in Texas we had for a long time no, and I won't use the word, but derogatory terms towards African Americans, no dogs and no Mexicans at restaurants and other public facilities. The lawyers on the case, who happened to be also of Mexican descent, the ones who argued at the Supreme Court, Gus Garcia, Carlos Cadena, and James DeAnda, they noted that when they were trying that case, they had to went to go to use the restroom and noticed that there were segregated restrooms in the Jackson County courthouse with a sign out back saying "Hombres aquí," colored men, "Hombres aquí," as opposed to the restrooms that were reserved for white citizens. So that they established a pretty good factual record. It's not as statistically robust as we see in voting rights in other cases, but certainly a record from testimony from people in the community that there had never been a Mexican American who had served on the grand juries or the petite juries, and that there was a significant population in the county that was Mexican American, and there were many who were eligible to serve but hadn't been selected on the rolls. And then the court goes on to point out that, and this happens again in Hernandez versus New York a little bit, but in this case they note nobody has a right to a proportionate or statistically exactly the number of people in the community reflected in a jury pool. But what people do have a right to under the Constitution is to prevent the systematic exclusion of a group of people, which was what was happening here. So I think in Texas, we continue to have, for many years, challenges to the election practices. Ultimately, the key man system, I think, was certainly challenged and ultimately avoided. In terms of the general significance of the case for I think our jurisprudence, our constitutional history, again, I think that the fact that this was a definitive definition of Mexican Americans as a suspect class with a documented history of discrimination in a U.S. Supreme Court opinion was very significant. Later on in another jury case, Castañeda versus Picard from I think it's Brownsville from the Valley, the court noted that by now it's beyond question that Mexican Americans are a distinct and protected class. And then Latinos, Hispanics becomes the substituted name for that eventually. Also, it's significant in that it was an instance of really what we would call de facto rather than de jure discrimination. There wasn't formally a law in the book saying Mexicans could not serve on juries, but that was the practice. Yes, I think that if the approach that the court applied, which was to hear testimony of systematic discrimination in the community with fact witnesses who established that, together with basically a presumption that given that there was a significant population, yet none had served, the court presumed the presence of discrimination. I think if the level of proof would have required the Hernandez team to show intentional discrimination by the key men, and they were men, in the grand jury system, I think that may have been a lot harder to prove that there was intentional discrimination. Rarely do you get a confession or admission of that, and then to prove it circumstantially you'd be right back where you are again. In other words, you have to look at statistics, you have to look at the absence of any that have been selected, and then the reasons given for that. For sure. And I think that what we see in Hernandez versus Texas, what we've seen in the country is sometimes sort of a proxy for discrimination. Sometimes Spanish language usage is a a proxy for discrimination or other things of that nature. And so, for instance, I like to compare Hernandez versus Texas with the other, I think, super important case called Hernandez versus New York in the 1990s. And in that case, again, remember how in Hernandez versus Texas, we had Strader, the grand jury, the jury case, and we had Norris, the de facto case. As to grand juries, Hernandez versus New York deals with the petite juries, the selection of juries in voir dire, et cetera. And in particular, the peremptory challenges, which we as trial lawyers can use to strike for any reason. But a case called Batson versus Kentucky from 1986 said that race was not a permissible reason to strike somebody on a peremptory basis. In other words, because they were African American. That was also extended to gender. Hernandez versus New York extends that to Latinos, Hispanics. And it's a very interesting case. I mean, I think every judge, despite there being several opinions, concluded that to be the case. However, what was interesting there is that the challenge, the explanation given in using the employment discrimination standard of prima facie proof of discrimination, then a neutral explanation for the conduct, and then finally the burden of persuasion and proof coming back to the person claiming discrimination to show why that's pretextual or not real. The reason given by the prosecutor in Hernandez versus New York was that the jurors spoke Spanish and that there would be testimony being translated through Spanish and that they might not accept the official translation. That's something we see all over the state, all over the country as a concern. And the notion that we're not striking them because they are Latino, but we're striking them because they speak Spanish, while not a direct 100% corollary. There are many Latinos who don't speak Spanish. There are many people who speak Spanish who are not Latino, but there's certainly a considerable overlap. Reminds me a little bit of that in the 1970s, the court found that pregnancy discrimination was not gender discrimination. Ultimately, Congress passed the Pregnancy Discrimination Act to change that. But here, the issue I think that persists, for instance, in jury service is somebody who speaks another language is certainly not disqualified by the fact of having that additional skill, speaking a second language, from serving on a jury. And so that Hernandez versus New York opinion, while correct in saying that you can't discriminate against Latinos and Hispanics serving on juries, is problematic and sometimes something that we bring up in voir dire to make sure that prospective jurors can follow the law and the translation, even though they may understand the original language. They can sort of have their own understanding, kind of like somebody who has a PhD in math might understand some calculations or some science at a higher level than perhaps others would, but they are not allowed to use their superior knowledge and experience in another context to try to influence the jury or to bring information that's not otherwise presented to the court. So that's a long-winded way of saying there are still many challenges. The Civil Rights Commission in 1968 found widespread discrimination against Mexican Americans in particular, but Latinos in the criminal justice system, and that remains a concern. The anti-immigrant rhetoric and also immigration is sometimes a proxy for discrimination against even citizens who are of Latino origin. And so these are all challenges that unfortunately we continue to face coming to the end of the first quarter of the 21st century.